Hello and welcome to our pre-Christmas Facebook Live,
Hello
TikTok
and
Live.
welcome
To our, we have a delay. Oh, is it over? It's over. Hello, TikTok universe. Good to see you. I see that some of you are already saying, hey, how do I ask questions? The best way for you to ask questions is to head over to our Facebook group because our facilitator, Brianna, will be there and will be filtering those questions and sending them over to us. But if you do ask the questions here on TikTok in the comments, I will do my very best to get them over to Julie and I in our live to answer them. Julie, happy December 22nd?
22nd.
22nd. How are you?
Good. I'm doing really good. I'm excited for Christmas. We had the solstice yesterday. The snow is actually melting off here in Sedona. We had a big snow last week. So it's feeling quite festive.
Yeah. So today we're going to talk about sneak peek into Win Without Law School. We're going to do our Q&A, but before we even get there, I want to talk about the solstice for a minute because I saw a video on TikTok that said yesterday was the longest night of the year. And today is the day when the days begin to get a little longer. And there has been, I think, a general like heaviness and just things have just been hard, just hard. And she was talking about like letting that go and then flowing into this next phase, which literally starts today and making things easier from that. Do you, Miss Sedona, have any insights on that?
So it's my understanding that, this is really what the December used to really be about, was celebrating the darkness and the transition to the light. And it's symbolic of an inner journey, during this cold time and when there's less light to kind of go inward and do some self-analysis and then kind of start anew coming into the spring where you start, the days get longer, you come into spring, you can start planting some seeds, start growing things. So this is kind of the time where you're figuring out what are the seeds that you're going to plant. What is that new light that you want to bring into your life? And it can be your life, it can be the world, it can be at any level, but it is a very symbolic time. And one common tradition is people will get what's called a Yule log. And it's like just a log you put in the fire, but you can decorate it. And then you'll write on a piece of paper what it is that you're wanting to call in. And then everybody's visions then get burned into the fire and of course put out into the universe from there. So.
Oh, interesting. So instead of burning what we don't want, we are burning what we want and watching it go up in smoke and permeate around us. Well, certainly there is some fundamental truth to this because you and I were just talking about how divorce month is January and filings go up. And it's not just divorce. It's if you need a modification or if you decide it's time to enforce or if you decide you need to move, all of these filings happen in family court in January. That must be related.
Yeah, I've always called it divorce season. The pattern that I've noticed is people will start thinking about it, like taking note, maybe in October or so, usually like August to October, like, oh, I'm not really happy. Maybe I want to make a change come January, and they start doing some planning. Some people will file before the holidays if they're very clear. Others will start gathering information and seeing how the holidays go. And then once the holidays are over, if they're like, wow, this still is not working, new year, new me, they'll file then. Others wait until Valentine's Day to give them one final chance to see if, love can be rekindled. And if they're disappointed after that, then there's usually another flow of filings, February, March timeframe. So that's what I've noticed. I did think that there was a bit of a pause more than usual in October this year. I think people are a little more uncertain about what to do because there is so much just uncertainty in general. But I also feel like there is this big movement, I feel it within myself as well, to reclaim ourselves and to really tap into what we want. And as we're going through those processes, sometimes relationships that once resonated no longer do. So I think there is a bigger shift, especially post-COVID, where people are getting a lot more clear on what's important to them and not just going through the motions just to go through them, but really figuring out, what do I really want? And there can just be some growths and shifts. And man, it's so hard. You know, there's so much emotion that comes with it, but there's also this opportunity to see this as this amazing opportunity to grow. And why do you have to stay as the same person you once were? You know, just because you picked a partner when you were in your 20s doesn't mean that's going to resonate in your 40s or 50s. And that's okay.
Right. More and more it is, you know, more and more people are kind of letting go of the guilt that comes with divorce, although it's still there. And even the topic of marriage is so heavy, especially for, like, I've got some gay couple friends that have been together 20 years and they're just now getting married. But like, to determine whether or not to get married, whether or not to turn that sort of over to the state and over to the laws and outside yourselves was a big deal. And for myself as a divorcee, I have this partner, I just adore him, but like the thought of getting married is almost stifling. And what do you think about that?
Well, I have a very unique point of view. I've never gotten married. I've said I never will. I started handling divorce cases in about 2009. And as a woman with a career, it became clear to me really quickly, like, why do I need to get married?
What's the upside? What is it?
So I've decided it's a no for me. And I never wanted the wedding. Like, I was never one of those girls where I like dreamed of walking down the aisle. Like, that wasn't important to me. So it wasn't a big deal, but I did feel a lot of pressure in my younger years to do those things. And, you know, when all your friends are getting married, you feel some pressure. I had just—
Has that gone away for you?
Oh yeah, completely. Yeah.
That pressure is gone. No, society is no longer pressuring you to get married.
No,
Wow.
In fact, I think a lot of people are kind of intrigued by my point of view. Like, oh, really? Oh, that's interesting. Yeah. Okay. Especially, it comes up a lot when I talk to female clients going through a divorce. And of course, they're like, oh, yeah, I wish I would have thought that before. But I've seen, it's usually this dynamic where the woman with assets who gets married gets kind of screwed over. I see that a lot. I see men protecting themselves much better than women do going into a divorce or going into a marriage. But that's just been my experience.
It seems to be a different exchange. So if men with assets get married, they're getting an organizer, a house cleaner, a support in them, their career. And when women with assets get married, it might be an equal partnership, but it's just not usually the same exchange.
It's not. I don't know why, but it's not. I think women have a more naive notion of love and what that means. Because I've had so many women say to me, well, I had to put the down payment on the house and put his name on it because we were in love and I needed to show him that it was real. And I'm like, no, you didn't need to do
that. Okay, so let's talk about Inside Win Without Law School. Registration is live. So exciting. This product has been in demand for as long as I've been a lawyer. Tell me about the course.
So this is really a passion project. Billy and I have been lawyers for nearly 20 years. We've been in the courts. We know our way around the courtroom. And so we're looking to take this knowledge and simplify it and make it so that those of you who either can't afford or don't want to spend the money on a lawyer because it is really expensive, that you have another option that actually serves your needs. Because there's a ton of different options out there on the market, but they're kind of piecemeal. They are really general. They may just give you some forms and say, okay, go figure it out. but there isn't something that's really there for you from start to finish that's Arizona specific, that also has this interactive component. So we're looking to provide a new we're going to provide a new platform for people. And there's a need. The majority of litigants walking into the family law courts are representing themselves. And right now, what are they doing to prepare?
Reading a few articles, reading the court's instructions. And I'm not sure if everybody knows this, but the law very clearly states that pro per litigants, people representing themselves, are held to the same standard as lawyers, which is mind blowing, because lawyers had to, go to college, get a degree in college, go to law school, get a 3-year degree in law school, pass the bar, then practice. And the law says that pro pers have to be held to the same standard. If you don't know something, if you miss something, it can be held against you.
Yeah, so most people are just walking in blind. They're just hoping that when they go in, the judge is going to figure it out for them.
Mm-hmm.
And that's a really horrible strategy.
Mm-hmm. It is a horrible strategy.
It's no strategy. And really, when it comes to the law is all about strategy. So you're missing a key component because you just don't know. And we want to help you know what to do and how to create a strategy. And so what we want to talk about today, I've got some points, I think Billy's got some as well to add, but we're going to talk about what are some of the key takeaways that you can get if you join Win Without Law School. So number one is, by joining Win Without Law School, you are going to get an explanation of what the hearings are and what to expect. So when your case is set for a resolution management conference, when your case is set for a status hearing, when your case is set for a hearing on temporary orders or oral argument or a final trial, we are going to decode that language for you and let you know how to prepare and what to expect. And that's really key, so that the minimal time that you have in front of the judge, you can make the most powerful impact possible.
Yeah, I think that is so wonderful. Some of the questions that we get in the Decode Your Divorce Facebook group is, hey, I have 20 minutes to convince the judge I need SoberLink. How can I do it? Which is such a good question. It's such a good question because she's been following our material and she knows that she has to start with her goal in mind, and her goal is, how do I get SoberLink? And she knows from our material she's got to figure out how to customize her approach to the judge, and she's doing everything exactly right. So how can we help more people think about their court hearings in that exact way? What am I hoping to accomplish? How am I going to present my arguments? How do I go back to the material that Billy and Julie gave me about how I'm going to structure my argument? What am I going to leave out? What am I bringing in? I'm so excited to see that this is working.
Yes. So understanding the hearings is really key. And by having this information, you're not going to walk in blind.
Mm-hmm.
Now, of course, going into the courtroom, various things can happen. You can plan and plan and plan, and you can still be surprised by what actually unfolds. But that's a lot different than just going in and blowing in the wind. And if you're going in without understanding what's happening, you're likely going to come away feeling like you got treated unfairly, because you're just not going to understand when the judge says, no, it's not time for that, I'm not going to hear it, but it's just because it's not the right hearing. And it's not that the judge doesn't want to hear what you have to say in general.
Right.
It's just there's a time and a place for that. And there's this concept called due process, and there has to be due process before certain hearings can take place. And so we can break all of that down, and you can enter the courtroom really like a professional. You can have your briefcase if you want, and have a trial notebook, and have a file. And I mean, you could really come in prepared if that's what you want to do. We can help you get there.
So many of my people here on TikTok are asking if they can ask questions. Yes, you can write down your questions, absolutely, and we will absolutely get to Q&A. And some of you are saying you don't have Facebook. I get it. Not everybody's on Facebook. Go ahead and leave your questions here. I promise we will get to them. Let's talk a little bit, though, about the format of Win Without Law School. How are we going to teach people 20 years of information that you and I have? How are we doing that?
So first, we've broken it down by type of case. So there's going to be 1 day of classes, which will be on Mondays, for people with a divorce case, and that's going to be with or without children. We'll cover both. So Mondays are the divorce day. Tuesday is child custody. So you have a child in common, you've never been married, and you don't have any custody papers in place. That's going to be Tuesday, which is called an establishment. You're going to establish your custody orders. So that'll be Tuesday. Wednesdays will be where I'll talk about how to modify either a divorce decree or a child custody establishment order, or how to enforce it. So Wednesday is what we call post decree. You've already been divorced, or you've already established custody, but you need to make changes or you need to enforce the terms. On Wednesdays, we're going to talk about that. And then on Thursdays, we're going to practice trial skills. So if you've got a litigious case, your case is going to trial. This is going to be a format where you can come in and get some trial experience in a really safe and comfortable place.
I think that is so huge. So you're going to get information tailored to you 3 different ways, depending on where you're at in your case. And then you're going to have the ability to actually practice trial skills. That's like a mock trial class.
It is. And with the information about, the Monday, Tuesday, Wednesday classes, we're going to go from start to finish. So we're going to talk about how to create a case strategy. We're going to talk about how to file. We're going to talk about how to respond if you've been served with the papers. And then requesting a temporary order, disclosure, discovery, settlement negotiations, trial. We're going to take you from start to finish so that you actually have a comprehensive solution, not just something that gets you started and that's it.
I've got a question here about the course. I'm interested in the program, but I'm confused on the process of how the courses will work. I assume there'll be a separate classroom with all the videos. Will the videos be released all at once or released at a weekly basis at a specific time? So for example, on week 1, can you choose to watch all 4 videos Monday through Thursday? How will that work? Great question.
Right, so we're going to be recording as we go. So after each session, it will be recorded and then it'll be uploaded into the members area. And you'll be able to access any of the course material. So it's not like, oh, I only have a custody case, but I can't look at the modification stuff. No, you can look at all of it if you'd like. So it'll be available as it's being created.
And then there's already some content that is available right now on demand.
Correct. Yes, that's right.
And that content is a 101 about the entire process, an overview of the process, a class on how to create a parenting plan, whether it be long distance, local, whatever. And then a course that Julie and I did on trial skills, which is so good. I'm having all of my attorneys take it. That's how good this course is.
So in addition to getting information on about what the hearings are and how to prepare, if you participate in Win Without Law School, you're also going to get an explanation of what the paperwork is. So there are a lot of papers that can be exchanged during a divorce or custody case. And it's just, a lot of words, a lot of paper. It can be really overwhelming without any explanation of what the documents are. And so we'll go through that. What's the preliminary injunction? What does that mean? What's the creditor notice? What's the parenting class? Just giving you a quick overview of what these things mean, because some of it's really simple and straightforward. You just need a quick explanation.
Right. And otherwise, you're making really strategic decisions. So we have a case in our office where we were trying to figure out, this person needs an order of protection. She's a victim of domestic violence. She's going to need to move to California. we, all 10 lawyers, are discussing, should we file for divorce and emergency orders because then the preliminary injunction goes in place and then she can't move, or should we just get the order of protection? And do we think we can get the kids on it? Like, this is high level stuff that you want multiple brains on. That's the other thing I love about Win Without Law School. You're going to get a community of people you can discuss things with.
Yeah, definitely. So the paperwork's really big. I think a lot of people too have a tendency to bury their heads in the sand and not even read the paperwork because it just brings up stress and anxiety. So I think that this will help alleviate that, because instead of you going through the papers and not really critically reading because you're just feeling stressed and nervous about what does this say, and am I in trouble, or whatever is going through your mind, you can know, oh, okay, well, Julie already explained this is the notice for creditors, and this is what this means in a divorce. And okay, all right, I'm okay with that. So I think that this could bring people a lot of peace of mind instead of like just this worry about, oh my gosh, what were those papers and what does it all mean? And I'm very confused.
It's so important because they have all this paperwork has legal consequences. Most people these days, I don't think, consume pages and pages of written words as the best form of communication to receive information. I think we know that scientifically. So being able to have somebody explain it orally while you're looking at it, while you're taking notes. Now, that's the way that we as humans can actually absorb information.
So another huge benefit of Win Without Law School is that we teach negotiation skills. Nobody really naturally has legal negotiation skills, especially when emotions are running high. Instead, what tends to happen is you end up just getting into this drama cycle where you're blaming each other for whatever happened in the relationship rather than constructively moving the dial forward to resolution. So we're going to provide tips and tricks and ways to actually engage in constructive settlement and move things forward. And that's not only with your ex, but let's say your ex is represented by a lawyer, which is a really intimidating situation, which a lot of people just run from. But really, there's a huge opportunity if you know how to engage with the lawyer. And that's another thing that we're going to help you with.
Oh man, I'm really excited. So from now until Monday, the price is $29 a week. On Monday, that price goes up, and it will continue to go up until classes start January 9th, right? January 9th is our
Monday, January 9th, we start.
Very, very excited. So you can register and you can join at winwithoutlawschool.com. Now, without further ado, we will get to your many, many, many questions. This is a good one. My current order states I can't move more than 100 miles. Is that radial miles or driving miles?
Driving miles would be my perspective on that. What's the difference mileage-wise? I have no idea.
I bet radial miles is a wider distance than driving miles, right? Probably, because radial miles is like straight line. And of course, no cars can get anywhere in a straight line. So probably driving miles, but I don't know that it's actually defined anywhere. It's never come up for me.
You know, this is one of those things where people get caught up on the mileage requirement, but sometimes that part of it isn't the most relevant. Because let's say you have a parenting plan where let's say you're on that, mom is Monday, Tuesday, dad is Wednesday, Thursday, you alternate every other weekend from there. So you have a lot of regular contact. If you're going to move 50 miles away, 70 miles away, like that parenting plan may not be workable anymore. So even if you're even if you're moving within the 100 miles, which you're allowed to do, that can still trigger a need to modify your parenting plan. So I would be looking at this more big picture, like let's not get too caught up on the mileage. relevant because if you're going over the 100 miles, you may need to trigger the relocation notification requirements. But regardless, even if you were moving 99 miles away, you still likely are not going to be able to use the same parenting plan that was drafted based on you living closer together.
You bring up such a great point. So what I think is one of the hardest things about family law is the system that we're in, the litigation system, is designed to have a winner and a loser, somebody who's right and somebody who's wrong. The law says X or it says Y, and you're going to argue your points and the judge is going to decide who's right. That is horrible for what we're actually trying to achieve, which is an ongoing workable plan that involves your child and two people trying to live their lives. So all these individuals are trying to figure out a way to live their lives, but also stuck in litigation that is very combative and pits them against each other. So there is like this huge tension in what the court says, work it out, and at the same time, file motions, respond to their position, duke it out. It's like asking them to sit down at a table and negotiate, and at the same time, joust on horses. It's really hard to navigate. Do you have any tips for that?
I mean, that's the approach we take, right? We extend the olive branch and we have the jousting stick in the other hand. And it's this dance that we do, and it leads to a resolution either between the parties or with the judge deciding. But yeah, it's that two-pronged approach, trying to resolve things, but also preparing for trial in the event negotiations fail.
Yeah, it is the only option we have. It's a system that, you know, we both probably agree is less than ideal for anyone, but it's the system that we have. Sometimes what we'll do is we will take a good cop, bad cop approach. So I've got one lawyer who's fighting with an opposing counsel and things are so heated, and we're talking about a baby who's very, very young. And I really would love to see them come up with something they can live with. And so I suggested that a different lawyer reach out to this opposing counsel to see if we can get an agreement to go to mediation. But one of the questions we had is, can I have somebody that is not a lawyer represent me?
If they're a legal paraprofessional, and that's licensed by the state bar, then yeah, you could have a legal paraprofessional represent you. But short of that, no. You're not going to be able to bring a friend or your mom or, you know, no, you can't do that. That would be practicing law without a license, which is illegal.
It is. It's illegal. It's illegal for somebody to help you in ways that constitute practicing law, which is a whole other topic that I think is challenging and problematic. But let's go to another question. Is it appropriate to put my son in one bedroom and a bed with 4 new step siblings, mixed gender, 14 to ages 4?
I mean, I don't think so. There's so many challenging co-parenting issues that come up. And, you know, we kind of talked about this, I think, last week, where this is a serious issue, but could you just run to the court over this? I mean, obviously, if something bad is happening in that bed with those kids, yeah, that would be a compelling argument for emergency relief. But what do you think, Billy? I don't like that question.
I mean, this is a legitimate issue. This is a legitimate issue. We have another case where that happened. A family blended. We represent mom, dad's family blended. One of her kids is sharing rooms with these new step siblings. And she found out that there was a previous issue with inappropriate sexual contact between the step siblings or with other people, something involving the step siblings. And so this happens all the time. Your question and the possibility, you've got these new people that are introduced, and you've got the practical arrangements of, like, you're divorced, right? So everybody's broke after divorce, and you're in a smaller space and there's fewer bedrooms. And if you're blending families, then there's a ton of kids, and these two new people are trying to figure out where to put the kids. And sometimes it's an emergency and sometimes it's not. And it's incredibly difficult to prove. We've got a different case where a little girl disclosed that her autistic brother had inappropriately touched her. So that's been a whole litigation case. It's been impossible to figure out the truth. So what is the best that the court and the parents can do? Come up with a safety plan, come up with an arrangement that everybody can live with that mitigates the risks, because we can never eliminate risks. So in this case, 4 steplings, mixed genders, 14 to 4. One question is, how old is your son? So this is about your son. How old is your son? Is your son the 14-year-old? That would make me nervous, because I wouldn't want my 14-year-old son accused of inappropriately touching somebody. And that happens. Those accusations happen, and issues between siblings and step-siblings happen. So if my kid was the 14-year-old, I would be super concerned. Let's say my kid was younger and there's another 14-year-old boy or girl. Would it matter if it was a boy or girl? Maybe I would feel differently if it was a girl. But okay, so the comment says that son is 7. So, I mean, all you can do, I think, in this case is reach out to the other party and see what you can figure out. See if
and I wouldn't come in attacking either.
Right.
Because I'm sure you're angry. But I wouldn't come in yelling and you got to do this. I would more be like, look, I have a concern. Can we talk?
Right. And maybe you point out this concern goes for all of them. There's a lot of risk in putting children who are not biological siblings, maybe even children who are biological siblings, but certainly children who are not biological siblings who are just getting to know each other in one bedroom. This is one of the reasons why. I'm sorry. Yeah. Quite
age range.
Yep. So this mom just wants her son to sleep separately, even if it's in the living room. That seems like a reasonable request. I don't know what the parenting plan looks like.
I'd consider getting a little blow-up mattress and being like, look, here's an extra bed that our son can use, put him in the living room. Like, I may even try to assist in the arrangement a bit.
Yeah. And if you need to, this is the type of thing that does get discussed in courts often. It is the type of situation that courts are asked to get themselves involved in. And that might help push it towards resolution, even if it doesn't end up with the court deciding something. Sometimes filing something to say, hey, I've got a problem, we need to get this sorted out, can help push the discussion forward. Ask for mandatory mediation. So I really do.
Sometimes that can change things. Sometimes the other side gets the court filings and then they change the sleeping arrangements. So.
Right. They change the arrangements, they get a new place, they take action. Sometimes we file in court, not because we need a judge or we think a judge is going to decide, but because we need to push an issue forward. Like sometimes if I have an opposing, if a child is in danger and there's any type of physical abuse going on, I will always file, because at the very least, it will improve conditions for the kid. The parent who was abusive is less likely to be abusive when under court scrutiny. And sometimes that's the best we can do.
Yeah, it can be a big wake-up call and can definitely effectuate change.
Sure. And sometimes I'll do that even when somebody is maybe not abusive, but their physical discipline is over the top. Because once you go to family court, you kind of can't do that anymore. And so it's a great way to influence your child's environment. Like there's a lot of cases where people are being hit in the head or whatever. And if you go to court and you complain about that, a judge is going to say, stop, which is helpful. Let's see. So I know, okay, what I'm getting here is that you have a lot more comments on TikTok. What we cannot do is give you legal advice. What we cannot do is read all of your situation and then tell you, oh, well, in that case, do blah, blah, blah. Like I would highly recommend you either join our course so you can get taught on how to represent yourself, or have a consultation with a lawyer, because Julie and I are not your lawyer. We can't give you legal advice. All we can do is discuss these issues in the theoretical when you bring them to us. Did I miss anything, Julie?
Nope, that's right.
Okay. All right. I want to modify child support and child custody. Do I go through the courthouse or the child support division?
Courthouse or the child support division. And she wants to modify, what does she want to modify?
Child support and custody.
So from my perspective, you're going to go back to whatever court issued your order that you're looking to modify. So you're not going to initiate a new case, but you're going to go under your same case and do a petition to modify or enforce. So whatever court originally entered your order, that would be my thought.
Right. Yeah. So the issue that I see here is many times parents will make an agreement to modify parenting time. They agree on it, you know, and they maybe do it for years at a time. Maybe they even agree to change child support based on their agreement to change parenting time. If the court isn't updated as to your change in parenting time, they usually won't use the parenting time credits differently in the child support calculator. So if, let's say in this case, you two agree on the parenting time change, I would recommend you file just a stipulated modification to change your parenting time. Then you can ask the Division of Child Support to modify your parenting time. Although it would be, or I'm sorry, modify your child support based on, because you've already updated your parenting time with court. So, oh goodness, let's see. What does it mean when your lawyer says he's protesting the other party's petition?
So one party files the petition. It could be a petition for divorce. It can be a petition to establish custody. It can be a petition for contempt, a petition to modify, a petition to enforce. So there's all sorts of petitions, but a petition is what is filed to initiate a family law case, either initially pre-decree or as part of an ongoing case, but post-decree. So if I'm going to contest a petition, then that means I'm objecting to something that's in there. So it could be some of the factual allegations that are made. It could be some of the requested relief. It could be both. Another way to object to a petition is to file a counter petition and say, okay, you're asking, for example, to modify the parenting plan to every other week. I'm going to counter petition because I want the parenting plan to be a 522 plan. So you can contest the petition by doing a counter petition as well. But overall, contesting the petition just means that you don't agree with everything that's in it.
Right, right. That is exactly right. Sometimes people will see what's in a petition and think, oh no, the judge is going to do this. I have to do something. You don't. I mean, you do have to respond, but just because the other side files a petition or a motion or whatever it is they filed does not mean that that's what the court is going to do. And you will always have an opportunity to contest, not protest, but contest whatever's in their motion or their petition. Somebody asked, how much is the course and where can you sign up?
So go to winwithoutlawschool.com. It's $29 per week for the time being, but that's going to increase next week. So winwithoutlawschool.com, just follow through the websites there. You'll find your way to the main page.
Absolutely.
And Billy, one other point, if anybody has any questions, you can also email us at info@winwithoutlawschool.com. So if you have any final questions that you don't want answered before you sign up, feel free to send an email.
Absolutely. You can email us at info@winwithoutlawschool.com or sign up at winwithoutlawschool.com. What happens when someone lies under oath?
Well, number one, the lie needs to be proven. You know, you as a party listening to someone testify may be confident that the testimony was a lie, but the judge doesn't necessarily know that. And so you would need to take steps to prove it. And if you were able to prove it, then, you know, that would be factored into the judge's decision. But unless you're going to initiate a civil case for perjury, it probably isn't going to go anywhere. It's possible that the prosecutor's office can file a criminal charge for perjury, but I've never seen that happen in my career. Not that I can think of.
Yeah.
But the judge could enter a very favorable order that awards attorney's fees and does other things if it's proven that, in particular, an opposing party lied on the stand. In particular, if the thing they lied about was material to the final outcome, you know, if they're lying about the child or something like that, or property and hiding property, the judge can issue some pretty heavy orders in that regard.
Yes. Most of the time, the answer is nothing. Most of the time, the answer is we don't have enough time to prove somebody's lying, or that's one of the reasons why we want to do things like depositions in advance. People who are representing themselves don't often do depositions, but I think depositions are so useful if you're going to trial, because what it does is it allows you to lock down their testimony. They cannot change what they're saying, or you have immediate impeachment evidence in terms of that deposition. Do you think we will teach people how to do depositions ever?
No, it's too expensive. You have to pay for a court reporter. You got to pay for the transcript. It can go up to 4 hours. No, I don't think so. But, you know, back to this question about the lying, I think, you know, this is another thing where you've got to separate out reason from emotion. Because if the alleged lie is something that may be really important to you, but really isn't important to that outcome, or, you know, what's at issue under the law, then it's just really not that important. Like, it's not right to lie on the stand. I'm not sanctioning it, but, you know, you can't expect the judge to go down every rabbit hole. I mean, the judge is looking at the big picture. And unless this lying is about something really significant, like let's say a parent violated the judge's order, you know, some sort of parenting order, and the parent clearly violated it and they're taking a stand and lying about it, like that's going to make a judge mad. And that's something really worth pursuing, to show, look, here's what the order is. Here's to show what they did. Here's to show they're lying about it. Like, that's good evidence. I would pursue that. Right. But if it's like they lied about asking their mom to babysit and you know, there's some stuff that is maybe really important to you, but the judge is like, I don't care what he told mom, and you know, it's just, and that's one of those, sometimes that can be hard to ferret out when you're really entrenched in the situation.
And it depends on the judge. Some judges are more concerned about these things than others, because judges are doing the same thing. When we talked about straddling the system between creating outcomes that work for families and winning the legal arguments, judges are straddling that same problem. They know they're making decisions with parents who are going to have to work together to co-parent children. They don't want to come up with something that makes one guy the good guy and one guy the bad guy. They just don't, because they know that doesn't bode well for future co-parenting. So it's such a challenging situation that I think judges find themselves in, and that this whole family court is just really hard.
Yeah, it definitely is. And that's something that I found useful going into the courtroom, is to not just look at things from my client's perspective, but to think, okay, as the judge, how's the judge thinking about this? And how can I influence the judge to see it more from my client's perspective? But if I'm just going in and only advocating my client's side, I may not be as effective as I could be if I'm taking more of a bigger picture argument and then showing why that favors my client. But that's something that I learned over time, you know, and I've also heard feedback from judges too about that, saying, you know, when somebody comes in and really isn't thinking about the child, they should really rethink it, because that's what my focus is on as the judge.
I think what you just said is so important. And I talked a little bit about the newborn custody issue in this live. So we represent mom. She's got a newborn. We went to temporary orders. Dad has a history of domestic violence. The court ordered weekends with this infant to dad. Mom is freaking out. But we went in and argued that dad should have only supervised time. We did not provide the judge any other mechanism. So now as we're brainstorming, how do we get out of this situation? One of the things we're thinking about is practical solutions. Maybe we can ask that the parties do a parenting class together, an infant parenting class. Maybe we can come up with other ways that the infant dad can be supported while he has the infant, because let's be real, dad's going to get time with this infant. So the more you can think about, what do I want? And also, if I don't get that, what else could I advocate? And how do I give the judge a roadmap that protects my children? Because you know your children better than this judge will. So understanding all of those things will really help you if you go in and pitch something to the judge. Okay, more questions. Bio mom is keeping the kids from seeing the dad. There's no court order. Will this reflect poorly in court?
On mom or dad? On mom?
Good question. I am so happy that you answered this way. Bio mom is keeping the kids from seeing dad. There's no court order. Will this reflect poorly in court? Talk to me about both ways. Is this going to reflect poorly on dad?
It depends. I mean, obviously we need to know more about why bio mom is keeping the kids from him and what the backstory is. Are there valid safety concerns, or is mom just using the kids as a pawn in her battles with dad? That's the real rub. If mom has serious safety concerns, then the court may honor her decisions. And since there's no orders in place, she's not violating anything. From dad's perspective, if mom is just doing this out of spite, then I would be looking to gather evidence in that regard and really trying to get the court involved to address the situation as soon as possible. But I think if dad does nothing and just lets mom go and doesn't have contact with the kids, that could be used against him. Now, if there's reasons why, if he's like, well, look, I couldn't afford a lawyer and I needed to work some and I didn't know where she was, like, there can be circumstances to mitigate that. And just because you lack contact doesn't mean you never will get reunited. But that certainly could be used against dad if he just does nothing at all.
I agree with Julie 1,000%. Both parents have an obligation, and this could blow up for either parent depending on the circumstances. So I love that. All right, more questions, lots more questions. Father's incarcerated his whole life. He gets out. Well, then he wasn't incarcerated his whole life, but this brother's incarcerated his whole life. He gets out. He wants partial custody. Can I fight that? I've had my son his whole life. The child is 6. I've been a single mom since I was 16, never had any CPS cases. Thank you for all that background. What do you think about that, Julie?
Well, the question was, can I fight it? And the answer is, of course. I mean, that's part of due process. You get an opportunity to object. So the simple answer is yes. But then we come back to what Billy said earlier, which is the court going to give him some access to his son, just like with the newborn? Yeah, probably. Will there be terms about when and how, and is it supervised and overnights or not, and public place or at home? Like, yes, there will be a ton of details, and there should be a reunification period and maybe some family counseling. I mean, there's definitely going to be a lot of different considerations versus just a normal parenting plan. But will this guy who's been, incarcerated for who knows what, and may or may not be fully rehabilitated and may or may not have parenting skills, will they get some time with the kid? Yeah, probably.
Yeah. Just because your kiddo's 6 and doesn't know his dad does not mean that I would be highly shocked if the judge said, well, dad missed out on the first 6 years. He's SOL forever. Not going to happen. So, and we had another case like this in our office. Mom was incredibly unhappy when the dad got unsupervised parenting time with the child. But Dad was working. Dad was remarried. Dad, I think, even had other kids. He was functioning in society. So that's one of the things we're going to want to know is when this man gets out of jail, what's his life like? Because they're not going to hold it against him. It looks like you guys, so if you were 16 when this baby was born, maybe you were both very, very young. It's just not going to be held against him forever. You're probably not going to get no contact. So start thinking about what could I live with? What would be best for my kiddo? How do I design something to let him know his dad? And if you can avoid family court because you start out not from a place of you're never going to see him, I would recommend you avoid it. Avoid family court. Try to come up with something that you can both live with if it's at all possible.
Yeah, and you may need to look at it from a child support perspective too, because he may be coming out of, prison and being like, oh, I need to get parenting time so I don't have to pay child support. And if that's his motivation, you may want to be like, hey, look, and again, this is a total personal decision. I'm not saying you need to offer this or anything, but hey, I'm willing to waive or reduce child support, and there are rules around this, but in exchange for you not, pushing for this parenting time stuff, or, I understand you need some time to get on your feet. I'm not going to push the child support thing, but you may be able to go that angle if that is the motivating factor on dad's side.
Okay, so somebody is asking, can you please read all of my comments and answer a question? And unfortunately, I want to let you know I really can't. So we've got a facilitator who's looking at the comments and getting the questions to me. She can read them. She can try to get me the question to the best of her ability, but that is our limitation during the live. So it's not that I don't want to, it's a real life limitation that we've got. Would a judge order a custodial parent to meet halfway when the non-custodial parent moves 1 hour away? Yeah. I think what they're really asking is that a reasonable thing for the other person to ask? Yeah. Dad or mom moved an hour away. They want to know, is it reasonable that I should be expected to meet halfway?
From my perspective, that's what usually happens.
Probably.
Think, Billy?
I mean, we're dealing in real life, right? Real life is this child's parents live an hour away. So then we have to go to real life. What's everybody's work schedule? What's the exchange schedule? What is the most of the time judges absolutely put transportation on both parties.
Yeah,
even if one party moves, both parties share in the burden of facilitating the parent-child relationship. It is rarely, if ever, put on one parent. And if it is, it's usually only for a very brief period of time. So yeah, the request is reasonable. And once again, we need to think practically, how can we make it work? What if my daughter's father... Ooh, this is a bad question. I don't like this at all. But here's the question.
Okay.
What if my daughter's father was making me send pictures of myself to see my daughter? I have proof.
How does he make you do anything? I mean, I don't.
What I get from this is dad has the daughter and dad says, if you want to see your kid, you have to send me naked pictures or I will not let you see your child.
Okay. Go to court to establish custody, get a temporary order. Like, I don't know why you need to go through him to see your child. So I would be looking to take that power out of his hands.
Exactly. This is about knowing your rights. And I understand that you may have had a power dynamic in your relationship where he controlled everything and you guys haven't broken out of that. You haven't broken out of that, but you don't have to send naked pictures in order to see your daughter. You just don't. And even if you don't have enough money for a filing fee, the court will waive your filing fee. You can go to the court and you can get an order. You might also even be able to get an order of protection or an injunction against harassment for texts like that. That's something to consider. Text messages can constitute harassment. And then, the order of protection won't get you parenting time, but it will call out that behavior and prevent that behavior.
You could potentially call the police on this too. I mean, there's some elements of criminal conduct here.
Right. I agree. And depending on what your situation is, if you're married or unmarried, you may already be the custodial parent. If you're unmarried, you may be the custodial parent of your daughter. You may be able to call the police and have the police get you your child. So you have far more options than you think you do. Is the proof that he texted you that helpful in court eventually? Yes, but let's focus on what we really want, which is getting your child in your hands and stopping this abusive relationship. Okay. I have sole custody. Can my daughter's dad say we cannot move to Texas?
So, sole custody, we stopped using that term in around 2012 in Arizona. We now have legal decision-making and parenting time, and then we also have a relocation statute. So you want to look back at your court papers, see if there's any language in there about relocation. Yeah, I mean, just because you have I'm assuming you have sole legal decision-making. Under the relocation statute, I think if you have sole decision-making, you don't have to give the advance notice. But we're back to that same issue we had earlier. If you're going to move, and that means you can't continue to exercise your regular parenting plan, or court-ordered parenting plan, that's going to need to be modified. So you may not need to get his permission to move, but you do need his permission to change your parenting plan.
Right. Relocation is complicated. The relocation statute is even complicated. It's 25-408. So ARS 25-408, and it has all these rules on what you need to do to relocate. But it says, even if you're allowed to relocate, you have to follow the parenting plan. So if you have sole legal decision-making and he has no parenting time, look at the statute. You may be able to move because you wouldn't be violating the parenting plan. But if he has parenting time and your moving would inhibit that, it's going to be a different story. So definitely check that out. All right. It is 11:58. So we have time, I think, for one more question. Let's see. Let me scan these because there's a lot of them. Oh, really good question. What's the difference between a deposition and an interrogatory question when it comes to proving they are lying? Or if they say something different on the stand versus the interrogatory statements?
Okay, so both the deposition and interrogatories are sworn statements. So a deposition is just like a trial, it's just not done in court. It's done usually at an attorney's office, in their conference room, and there's a court reporter there. But what happens is there's a witness called and put under oath, and questions are asked, and it's documented by the court reporter, and it's deemed, under oath testimony. An interrogatory is where you send a document to the other side, and that document contains a list of questions that you want the other side to answer. So an interrogatory is a question to the other side, and they are supposed to answer those questions under oath. So then this is where the real trial preparation comes in, because if you are anticipating that this witness or this party is going to testify differently than how they did in the deposition or the interrogatory, you need to have that paperwork ready as one of your exhibits. You need to have the deposition transcript. You need to have the interrogatory answers. You need to have those as exhibits, so that if they testify differently, you can confront them with the under oath statement in the deposition or the interrogatory to show that they're not being honest.
Absolutely. Both of them are sworn testimony. Both of them can be used to impeach your witness. Really, really great question. All right. We are out of time for today. We really love doing these. Thank you all for your participation and your questions. Make sure you check out winwithoutlawschool.com. The price goes up on Monday, and we would love to be able to teach more people how to rock it in court. Happy holidays to you, Julie. I hope you just have the best time.
Yeah, you too, Billy. We'll be back next week, I believe at the same time. So if we didn't get to your question today, try next week. Have a great holiday, and
when is it next week? Let's give people I don't even know.
Thursday at 11, same time.
Thursday at 11. All right, 29th. The 29th at 11, we will be here. And thank you all so much. Sorry to interrupt you, Julie.
Yeah, no problem. Visit winwithoutlawschool.com. We would love to have you in our classes next year.
Bye.
All right, bye.